Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence, in particular hearsay, and now we're into hearsay exceptions, and specifically we're into the 804 exceptions, the necessity exceptions. And why are they called the necessity exceptions? Essentially because our declarants are unavailable. We've established through 804A that there's some reason where they're unavailable. Maybe they're dead, maybe they have lack of memory, maybe they're injured, maybe we couldn't reach them with subpoena and they're not here. But for whatever reason, maybe there's privilege, they're unavailable for trial. So these are some of the exceptions that we can turn to only when we satisfy that unavailability foundational requirement. And really the way you need to think about it, this is almost a super foundational requirement. If you're answering an essay, if you're considering exceptions as the proponent, the opponent said objection hearsay, and as the proponent, you're scrolling through the definitional options, the not hearsay definitional options under 801D, and then you're looking at all the exceptions. Do not go to these 804 exceptions unless you have something in the fact pattern that you can make an argument as to unavailability. You never want to be in the position of saying, well, the problem doesn't say it at all, but I'll assume that the declarant is nowhere to be found. I'll assume that the declarant is dead. You don't want to do that. Only talk about 804 when you know the declarant is unavailable. It is a super foundational requirement that you should not pass go until you establish it first. I'm not going to go through these, but here are the 804A qualifications for. And one of the things you can think about is they all need something more than standing on your feet and responding to an objection. This is not something you do on the fly. And you can see they almost all of the grounds require the court requires some type of procedure, right? Even privileged court has to recognize it. If they're refusing to testify, it has to be despite a court order. If they're absent, it has to be demonstrated absence. It has to be efforts proved. Memory, we're going to go through that on the record. Even death, we have to demonstrate. Incapacity, we have to demonstrate. So you do not go lightly into unavailability. This is something that has to be spelled out in the problem. Sometimes in a multiple choice, in a bar exam type problem, they will say the declarant is unavailable, and the declarant said they'll just spell it out and get to unavailability. Otherwise, they have to be talking about these 804A requirements. So former testimony, first, that super requirement, have to have unavailability before we talk about the rest. But really what we're talking about is we're taking an entire block of testimony. We're taking a time when this witness came in to court, had a proceeding, had a hearing, had a deposition, had something on where like the whole thing happened. They were asked their questions on direct, they were asked questions on cross because the same party was here with their attorneys. They had the same motive, they had the same opportunity to develop that cross-examination. And now that they're unavailable for our trial, for game day now, big block of ice, we're able to pick up that whole thing, direct, cross, redirect, and plop it into this trial because we feel that it's fair enough that the same type of players were there or the same type of interests were there in a civil case with a predecessor and interest, and they had the same motive to develop the testimony. They had the same opportunity to develop the testimony. Everyone was there, so it's fair to pick it up and pull it in. So you don't get to former testimony lightly. This person has to be unavailable, and they kind of had to do it the first time. Easiest way to think about it, especially if in a criminal or civil case, because the rules differ slightly, is think about it in a criminal case. If we had trial number 1 results in a hung jury, but the agent testified, going into trial number 2, it's a hung jury. That means there's no result. There's no finding of not guilty or guilty. We're going to just go into trial number 2. We're going to do it over again with a separate jury, except between that trial number 1 and trial number 2, the agent is no longer available. They're unavailable. Maybe they're dead. Maybe it's privileged. Maybe they can't remember. Something happened to them. So the proponent, the government, really wants to look back at that trial number 1. Can I pick up that big block of ice that was the agent's testimony and bring it over here and dump it into trial number 2? Did it happen? Of course, the agent is unavailable. We talked about that first. Cannot go to this exception unless they're unavailable. Was it given at a trial hearing or deposition? Absolutely. It was in the formal setting. And then it was against this party. They were here and they had the same opportunity and the same motive. It doesn't mean they asked questions. It doesn't mean they did a good job. It just means that the same opportunity and same motive to develop that testimony. And in that circumstances, we would allow that whole testimony to come in. While it might be hearsay, an exception applies. This is 804B1, former testimony, and the entire testimony can come over and be plopped into our trial number 2. Anything short of that, if it's not at a trial of testimony, the popular tricks are really look out for times when defense counsel is not going to be there. Grand jury, defense counsel is not there. So this witness could have testified in grand jury. And then if they go unavailable before this trial, well, you can't bring that ice cube over. You can't bring that big testimony over because the defense counsel, the other party, wasn't even there. So they couldn't have cross-examined. So they can't have the same opportunity and motive to cross-examine. Same thing with a plea colloquy. Same thing with a preliminary hearing at times. Same thing with a suppression hearing. Maybe you just don't have the same motive to ask questions at those hearings. You at least have an argument to that. So make sure you look at, I'm bringing over the whole testimony and I'm bringing it into this trial, and I need these foundational requirements to bring that whole thing over. It's not like prior inconsistent statements where I'm only bringing that which is inconsistent. It's not like refreshing recollection where I'm only bringing the part that the person didn't remember. We're bringing over the whole testimony because they ain't here. It's a good way to think about it. So here's the returning to that diagram. Remember, you start with unavailability. You're having a whole analysis of unavailability first before you go into any of the 804B exceptions, particularly former testimony. And you're going to talk about why. Is it privilege? Is it memory? Is it refusal? Is it death? Is it absence? And then you're going to talk about these foundational requirements. And there is one difference to talk about. Criminal, you need the exact same parties there. You need the exact same defendant's counsel needed to be there the prior time, or else it doesn't work because of their constitutional rights in a criminal case. Civil, be real strict on what it means to be a predecessor in interest. It has to be someone that had the same opportunity and the same motives to develop the same testimony that we're going to allow from trial number 1, proceeding number 1 into this trial. But we do allow some sort of difference in a civil context. And we do not in a criminal context as it relates to that prior testimony. But just think about this. This is very difficult to do. We want a suitable substitute for the testimony that would happen at trial if this person were here. It happened at some other place. It's happened at some other hearing or proceeding or deposition. And we're going to pick it up and bring it on whole in here. And all these foundational requirements, including unavailability, need to be met.